On February 25, 2019, Paul Canero was indicted by a Monmouth County, New Jersey grand jury on 15 counts, including 4 counts of first-degree murder and aggravated arson in connection with the deaths of his brother Keith Canero, Keith's wife Jennifer, and their 2 young children, Sophia and Jesse. The indictment followed an investigation into the November 2018 events in Colts Neck, New Jersey, where the victims were found shot and stabbed before their estate was set on fire. According to the investigation, Paul Canero had been embezzling money from the company he shared with his brother. Evidence indicated that Keith had discovered the embezzlement and was prepared to expose it. With Keith's family dead, Paul Canero also stood to become one of the primary beneficiaries of his brother's pension fund, valued at approximately $3 million. The case was heard in Monmouth County Superior Court before Judge Mark Lemieux more than 7 years after the homicides occurred. Following extensive pretrial litigation, the jury trial began on January 12, 2026. On February 10, 2026, a procedural conflict erupted outside the presence of the jury. The defense attempted to introduce digital evidence that had not been previously disclosed to the state, leading to a sharp exchange between Judge Lemieux and defense attorney Monica Mastalone.
But my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes. Is it electronically stored? As far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before. So you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it. But I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are 2 distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So, yeah, you did have time. You absolutely had time to turn it over, and it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute. We want to do some research on this before it comes out on the stand. Tier says one thing. It does. But Tier does not mention, and it does not deal with the fact, when something, it's not created by you, no one's asking you to create anything in this case, it already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This in this court's opinion aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it, and you didn't turn it over. So if your answer is anything other than when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all I can say.
That is...
If Your Honor disagrees, then Your Honor disagrees. That's all I can say.
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance, so the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered Tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate, to refresh her recollection, would have been what you had in your possession, which was the screenshot, which included underneath the word "read," which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then, when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form.
Judge Lemieux expressed his frustration to Ms. Mastalone for the non-disclosed evidence of electronically stored information. Under New Jersey Court Rule 3.1.3.3, the defense is bound by reciprocal discovery obligations, requiring the disclosure of all tangible data, documents, and electronically stored information intended for use at trial. The purpose of this mandate is to preserve the integrity of the adversarial process by ensuring that all relevant evidence is vetted and verified before it is presented to the jury. The defense had allowed its witness, Ms. Katie Canero, to prepare testimony about data stored on an iPad, data that had never been turned over to the prosecution before trial. Ms. Mastalone argued that the witness would simply elicit the testimony verbally. Judge Lemieux rejected that reasoning, invoking State versus Knight. The standard State versus Knight underscores the ongoing duty of counsel to disclose digital metadata and electronic communications. The judge emphasized that a witness's verbal description of a screen is not a legally sufficient substitute for the actual electronic document. Judge Lemieux clarified that when a witness intends to rely on electronically stored information, the underlying digital record must be turned over to allow the state an adequate opportunity to verify the data and prepare for cross-examination. Otherwise, it could be considered a trial by ambush.
The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Mastalone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions, as I did before Katie Canero's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There's a 25-page ex parte letter that pertains to Corey Canero. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Canero.
Didn't I rule as it relates to any post behavior by Corey and/or his wife or ex-wife that I was not going to allow some of this conduct to be brought out. Didn't I say that in my January 27th?
Absolutely, and this wasn't
Okay,
a
so
decision
hold on,
that
hold on,
reason.
hold on.
It was just failure to investigate and seize and search the iPad.
No,
And
no,
also
it's actually not, because the first thing that you say,
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes,
The
exactly.
reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020. A contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
Judge Lemieux also made clear that his concern was not with the conduct or character of a third party, but strictly with what the evidence in the record could legally support. According to Mr. Canero's defense, the youngest brother of Keith and Paul, Corey Canero, also had financial motives to want the death of Keith by getting compensated with a part of the pension fund. Under Federal Rules of Evidence, Rule 403, the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Judge Lemieux determined that the probative value of Corey's behavioral quirks was substantially outweighed by the risk of misleading the jury and causing undue prejudice to the state's case. Under the standard established in State versus Kadadish, for a defendant to introduce evidence of another's guilt, they must show a link between the evidence and the victim or the crime. The court found that mere observations of a person's behavior or subjective lack of grief do not meet this evidentiary threshold and are inherently speculative because of the absence of a direct nexus between Corey's emotional state and the commission of the crimes.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house and getting stuff out?
Judge, could I just...
It might have been a mix between Petrozello and Detective Vogt.
I think there
Who
was...
specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no...
You know what I'm asking you. We're not talking about AIG. We're talking about the fact, what's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
at this point in time, I don't specifically. I don't have a recollection of exactly where that came in the trial.
Okay.
I know I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure. I know it's a fact we knew. I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case, but number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not saying that I'm right. That's why I'm asking these questions, because I don't think it exists, and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge Lemieux further explained that his concern in this line of inquiry was directed at what was properly in evidence, not at what either side may have known about the case through other means. Under the doctrine established in Hickman v. Taylor, an attorney's mental impressions, conclusions, and litigation strategies are protected from discovery by the opposing side as attorney work product. However, that protection is not absolute. Courts have consistently held that it disappears the moment an attorney chooses to weaponize that knowledge at trial. That is, to use it as a sword rather than a shield. Once the defense decided to have Ms. Katie Canero testify about the iPad data, the knowledge was no longer a protected work product. It became discoverable evidence. Under the Federal Rules of Evidence Rule 602, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Because the defense didn't disclose the evidence, Ms. Canero's testimony remains an unsupported assertion rather than substantiated evidence. Failing to recognize this shift is what Judge Lemieux characterized as a deliberate tactical error by the defense.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony, and I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible piece of information, I don't know. It was in the discovery, and they don't have the iPad. So from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple of days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutor, is there something you want to say before?
Judge Lemieux also denied the defense's contention that the court's evidentiary rulings constituted a violation of the Sixth Amendment. Under the standard articulated by the United States Supreme Court in Holmes v. South Carolina, the Sixth Amendment guarantees a defendant the right to present evidence that a third party committed the offense with which he is charged. This right is a cornerstone of the constitutional guarantee of a meaningful opportunity to mount a defense. Judge Lemieux did not dispute this principle. However, he countered that the Sixth Amendment does not confer upon a defendant an unfettered right to introduce evidence that is otherwise inadmissible, speculative, or irrelevant under the established rules of evidence. Judge Lemieux reiterated that the court is obligated to function as a gatekeeper under Rule 403, carefully balancing the probative value of any proffered evidence against its potential for undue prejudice, confusion of the issues, or misleading the jury. Because the defense had offered no forensic evidence, eyewitness testimony, or other direct proof connecting the alleged third party to the crime scene, the court found the theory of third-party guilt to be pure conjecture, constitutionally permissible as a concept, but legally insufficient as presented. The judge ultimately clarified that the issue before the court was not a Sixth Amendment question at all, but rather a straightforward matter of compliance with the rules governing electronically stored information. On February 13, 2026, Paul Canero was found guilty on 15 counts, including 4 counts of first-degree murder, aggravated arson, possession of a weapon for an unlawful purpose, and misapplication of entrusted property. On May 12, 2026, a judge is scheduled to sentence Paul Canero, who faces a potential term of life without parole. This case underscores the critical tension between zealous advocacy and the mandatory discovery obligations that underpin a fair trial. When a defense introduces late-stage digital evidence in support of a theory of third-party guilt, it challenges the structural integrity of the adversarial process itself. Judge Lemieux's firm intervention highlighted what the court perceived as a deliberate withholding of evidence that counsel had long been aware of, held in reserve until the trial reached its most consequential stage. By rebuking such trial-by-ambush tactics and enforcing strict adherence to procedural rules, the court affirmed its role as a gatekeeper of fairness, ensuring that neither side is prejudiced by surprise. Ultimately, these judicial actions safeguard the constitutional balance, ensuring that any verdict rendered is grounded in a transparent and lawfully disclosed evidentiary record. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe and share as we continue working to promote a more informed society.